What are your tenant rights during level 4 of the lockdown? During level 5 of lockdown, regulations 11CA made it clear that even with a court order, no person can be evicted from their place of residence. Evicting anyone during that period was an offense, and if found guilty, you would have to pay a fine, go to prison for up to 6 months, or both. From the 1st of May, the country shifted to level 4, and the new regulations relating to evictions were released on the 29th of April 2020. In today's episode, we will be taking a look at how the new level 4 regulations have changed the status of evictions during the national state of disaster. I'm your host, Zacharia Mashele. With me for this important discussion, I have Ms. Danielle Louw, an attorney for Ndifuna Ukwazi Law Center. Welcome, Danny.
Hey, Zach. Thanks for having me.
So, Danny, now that we are at alert level 4 of lockdown to curb the spread of COVID-19, can courts hear applications for evictions?
So let me start my answer by first reminding everyone that an eviction without a court order is always illegal. If a tenant fails to vacate the premises despite their lease being cancelled and notice to vacate being given, a landlord must follow the lawful eviction process to force the tenant to vacate their property. This is in terms of the law which existed prior to the lockdown, which has not changed since lockdown. What has changed because of the lockdown is when a landlord is able to approach the court to start the lawful eviction process. This is because there are strict rules during the lockdown regarding when and for what purpose courts can be accessed, which have been put in place to limit the spread of COVID-19. In terms of the COVID-19 regulations, which are also called the risk-adjusted strategy regulations, it is possible for courts to hear eviction applications during lockdown level 4. When and how an eviction application can be made and heard by a court during level 4 is subject to the specific court's relevant directions.
We know that during level 5, courts couldn't make an eviction order. Can a court make an eviction order during level 4?
Yes, they can. So in addition to hearing the application for an eviction order, the court may also decide to grant an order for someone's eviction, provided it is just and equitable to do so.
And can an eviction order be carried out or executed during level 4?
So in terms of the regulations, the default position is that an eviction order cannot be executed until the last day of level 4. But if the court is of the view that it is just and equitable to execute the eviction order before the end of level 4, then the eviction can be executed and the sheriff can then physically evict you. But this will depend on the circumstances of each case.
What are the circumstances that the court will consider here?
So the court can consider any issue to decide whether it will be just and equitable for the eviction order to be carried out during alert level 4. But some key factors must be considered. These are the reason for the eviction, the personal circumstances of the tenants to be evicted, especially whether there are any children and or people with special needs living in the premises, whether there is alternative accommodation available, and lastly, of course, the possible risk that tenants would be exposed to COVID-19 should they be evicted.
And what can a tenant do about an illegal eviction during lockdown?
So it's important to know that an eviction without a court order is actually an offense in terms of Regulations 19 and 31.2 of the COVID-19 regulations, and in terms of Section 8 of the PI Act. As such, the police must intervene if someone is trying to evict you unlawfully. A term in your lease agreement that says that your lease can be cancelled and that you can be given notice to vacate does not allow a landlord to force you to leave your home, even if you have not been able to pay your rent and your lease has been cancelled. The lease agreement is not the same as a court order. Only an order of court handed down by a magistrate or judge allows the landlord to lawfully evict you. So if someone tries to evict you without a court order, inform them that their action is unlawful and that they can be arrested, fined, or imprisoned, or both. And if they persist, call the police to come and stop them. An illegal eviction can also be reported to your local police station or the Police Crime Stop and Anonymous Tip-Offs line at 086 0010 111. The number again, 086 0010 111.
So if the police have a duty to prevent an unlawful eviction, can they also assist in carrying out an eviction?
So only a sheriff and persons authorized by the court to assist the sheriff may carry out an eviction order, provided that the sheriff must at all times be present during such eviction or actions authorized by the court. These are also subject to the conditions determined by the court. The police may be requested to assist the sheriff to ensure law and order in situations where the sheriff and their employees may be exposed to injury, death, or damage to property. As such, members of the police may not participate in the eviction, but may provide protection to the sheriff and their staff.
So we've learned that landlords are not allowed to evict someone without a court order. But what about municipalities? Can municipalities demolish someone's shelter and evict them?
The municipality also has to follow the law. The municipality can't evict you from any shelter or structure that you are already living in, even if you have only been living there for a short period of time. The municipality is also not allowed to demolish your shelter or any of your belongings, which include your building materials. They are only allowed to evict you with a court order that specifically allows them to do so.
What can tenants do if the municipality threatens to evict them, or damage, or destroy their property?
So tenants should take photos or videos of the officials doing this to them. They should also try to write down the names of any of the officials and whether they are the police, municipal law enforcement, anti-land invasion, or the Red Ants. If the officials hide their names, tenants should write down or take photos of their vehicle registration numbers. They should also contact the legal support hotline, a public interest legal organization, a private lawyer, or their local ward councillor for help. For persons who are living in high levels of informality, we suggest that even if you have not been threatened with eviction, you should take dated pictures and videos of your home and keep them as a record of the fact that you have been living in your home for some time. This will be important in case you are ever called to prove that your home is your home.
Thank you so much for joining us, Danny.
It's a pleasure. Thanks so much for having me, Zach.
If your rights are being violated during lockdown, there is a hotline number with the public interest law organizations that may be available to assist free of charge. The number is 066 076 8845. The number again, 066 076 8845. Thanks for joining us.